So I guess, folks, with the COVID-19 pandemic disrupting supply chains, we've heard a lot about that today, increased challenges, increased opportunities, the pressure for the public sector to deliver essential goods and services. The risk of fraud is all too real. It's all too real, folks. So in this session, the Competition and Markets Authority, the UK competition regulator, will provide advice and guidance on how to identify areas of concern, to spot those red flags and highlight risks. Folks, we're being joined today, and the session is going to be led by Georgina Laverack, who is Assistant Director for the Cartels team, and Lars Suhr, Technical Specialist for Payment Systems Regulator, Legal Competition team. And Lars wins the competition for the longest job title today. So I'm going to hand over now to Georgina and Lars, and we'll take any questions at the end of the session. If the guys can start the slides now, that would be great. Thank you.
Great, thank you. Thank you very much for that introduction, and thank you for inviting us today to your conference. We're really keen to come and sort of spread the messages and things that we've been working on. So this is a great opportunity to come and talk to you. So I'm Georgina Laverack, as just been mentioned. I'm an Assistant Director in the CMA's Cartel Enforcement team. And it's our job in the Cartel team to try and uncover and stop the type of illegal business activities that Lars and I are going to talk to you about today. So I'm joined by Lars from the PSR. So I'll just let Lars introduce himself.
Yes, hi everybody. Also, thanks for the warm welcome. So I'm a technical specialist in the competition team of the PSR, and we are the regulator for payment systems, as the name suggests. And like the CMA, we also have competition enforcement powers. And I'm here in particular to talk about a competition case we've recently finalized as the PSR, and was our first competition case, and it's quite relevant for public authorities. So it should be hopefully of some interest.
Great. Thank you, Lars. And what we are, one of the things that the CMA and the PSR are both tasked with is protecting consumers from being ripped off by these illegal business cartels. And they are, in essence, anti-competitive agreements between competing businesses, so rival businesses selling the same goods or services. And cartels that affect public procurement can increase prices by 20% or more. So that's come from research by the OECD. So it really can have an impact on your spending levels. So why are we here? We see bid rigging and market sharing. These are both types of cartel activity as a key risk for public procurement. And public procurement is economically very significant. It represents around 1/3 of all UK public expenditure, and it covers a large range of goods and services. And the UK spends some £290 billion on public procurement every year. So if you consider the sums involved and the fact that bid rigging can inflate prices by 20% or more where it's present, then you can see how harm can result from this sort of behaviour, and that harm is felt throughout society. It's experienced by taxpayers and all of us who use public services and public infrastructure. So it's important that we're all on high alert to the risks of bid rigging. And what we're going to do today is try and help you understand more about what illegal anti-competitive behaviours look like in relation to procurement. We also want to help you spot suspicious or potentially anti-competitive behaviour and where it might be happening in projects that you handle. And then also we want to give you an understanding of how to report to us if you do come across anything that's suspicious, and to come to the CMA and PSR. So if I move on to my next slide, thank you. Yes, a little bit of background about the CMI and the PSR. So what we do, the CMA, as has been mentioned in the introduction, is the primary competition and consumer authority, and it's independent of government. We came into being in 2014, but we existed before then in that we were part of the Office of Fair Trading and the Competition Commission, and those two bodies came together to become the CMA. We've got offices across the UK nations, so we've got offices in Edinburgh, Belfast, Cardiff and London, and we've recently announced expansion into Manchester and the Northeast. So we're having an office in Darlington. And as we're here mainly talking to a Scottish audience, here here's some information about our presence in Scotland. In 2018, the CMA started the process of expansion in Scotland, and our Edinburgh office now has 50 staff. And from the summer, we are based in the, from this summer, we've been based in the new government hub off the Royal Mile in Edinburgh. And our staff in Scotland represent a range of expertise and specialisms working across the CMA's functions, including work that we're talking about, but also covering consumer protection, mergers, and markets work. And the CMA's devolved nations team is responsible for advocacy and stakeholder outreach in all the nations. And that includes stakeholder outreach to government and parliament, businesses, and to consumer groups. I'll hand over to Lars.
Thank you, Georgina. So I've already mentioned payment systems regulators, the regulator of payment systems, and I'm here to talk a bit about not our regulatory powers regarding payment systems, but in particular our competition powers. The interesting thing about that is basically in the UK, it's the CMA, which Georgina rightly said is the primary competition enforcement agency. But in the UK, we have a setup where we have a so-called UKCN, UK Competition Network. So a lot of regulators like Ofgem, Ofcom, and so on, they also have competition powers, and so does the PSR. And we're all working with the CMA together, basically, to enforce anti-competitive conduct in the sectors effectively. Broadly at the PSR, we have three objectives: the competition objective, the innovation objective, and the service user objective. And payments is actually quite a hot area in the sense, if you think about developments there like Apple Pay and all the stuff, Visa and MasterCard, and there's a lot of innovation happening. So innovation is also important here. Because Georgina talked about the Scottish footprint of the CMA, we also, even despite being a small authority, we also have a tiny footprint in Edinburgh. So we have an Edinburgh offices. Essentially, as the PSR, we are sharing offices with the Financial Conduct Authority. So both FCA and PSR, we're based in London and Edinburgh.
Great.
Thank you.
Thank you. So if we move to the next slide, please. So what are we talking about when we are talking about business cartels? So what all business cartels have in common is that they undermine competition and they essentially cheat customers out of getting a fair deal, or they cheat sort of customers from having a level playing field. And effective competition helps to ensure value for money, but also better choice and quality and innovation. And common cartel behaviours are listed on this slide here. So we have price fixing, which is where competitors agree what price they will charge. So they agree together, or what discount they will give. And they do this in order to avoid competing with each other. The second sort of main type of business cartel is bid rigging. And this is where businesses, competing businesses, agree together how much they're going to bid in a tender and who will have the lowest bid so that they will win the contract. And thirdly, the main area of cartel activity is market sharing, where competitors agree not to compete for each other's customers, or they decide which territories or which areas they will take, and so that they will serve and prevent others from competing in that area. So those are the main types that we're talking about as of business cartel. And we've got a big message to get out, which is how serious these types of behaviour are. And in a recent survey, we did find that half of businesses didn't know that agreeing with competitors to charge the same price, or dividing up and sharing customers with competitors, or discussing details of tender pricing could be illegal. So we have quite a lot of campaigns work where we go out to industry to talk at industry events to raise awareness of this sort of behaviour and the fact that it's illegal. And as I've mentioned, this type of behaviour can cause serious harm and increase prices. So if we go on to the next slide, please. So what we want to specialise or focus on here in this talk is bid rigging, because that's the most common form of cartel activity that you're likely to come across in public procurement. So it's important to understand what bid rigging is if you're procuring goods or services, so that you can spot it and report it to us. Or if you are a company bidding for a contract, you need to ensure that you avoid this type of behaviour. I've mentioned that bid rigging can inflate prices, and also bid rigging comes in a variety of different forms, all designed to manipulate the tender process for the contractor's benefit. So the different forms of bid rigging are listed here on this slide. So just to run through them, bid suppression is where companies agree not to submit a bid at all, which means that other firms face less competition. And this is normally done in exchange for some sort of kickback or payment, or part of an arrangement where the winning bidder then subcontracts part of the work to the non-competing firm. So we also see bid rotation, which is where companies agree to take it in turns to have the most competitive bid. And the other competitors submit an inflated, they take in turns to ensure they have a fair share of the market. So they agree between them who's going to bid the most attractive bid. Cover pricing is where competitors who are taking part in a tender a firm might decide it doesn't want to take part, but instead will submit a inflated cover price to make the price look higher. And then we also have customer or market allocation, and this is where competitors agree to divide up customers or geographic areas, and that they will not bid or will not submit, or would not submit a competitive bid. So they might just do a token bid in the areas that have not been assigned to them. So those are the sort of four main areas that we come across. And cartels can occur in pretty much any industry. We've taken cartel cases in a broad range of sectors over the last few years, ranging from modelling agencies through to estate agents, and several cases in the construction industry. And the PSR has taken a case in the payment system used for welfare benefit distribution, which Lars will cover more in the next slide, or not next slide, sorry, the one after. If I could go on to the next slide, please. This summarizes some points I made at the intro, and I sort of put them up front because I think they're the points about how bid rigging can increase prices, but also is a key risk in public procurement. It's important to say up front because that's why we're here. I've mentioned that we've taken a number of construction cases in recent years. So in the last few years, CMA has fined construction firms £67 million in total across 5 different cartel cases. And these cases affected public procurers or publicly funded projects. I'll move on to, pass on to Lars to continue on this bit.
Thank you so much. I mean, yes, I'm here to talk about the PSR case. The first bullet addresses here, like we fined 5 businesses recently, 33 million in total for market sharing in the prepaid cards market. And the next slide, I'll go into detail about that a bit. The really interesting thing is that this was a cartel behavior, which was actually targeted at public bodies, which is why I'm here. In particular, local authorities were targeted, but not only them. And the prepaid cards which were used, they were used for welfare payments. I'm going to talk about that as well. High-level points here for this slide is still, think about the collusion is more likely in times of economic strain. And then you think, what kind of times do we have right now? But it's kind of logical, you know, if the business is booming, the market is expanding, then maybe firms don't feel the pressure as much. But if there's pressure, and if the budgets are tighter, then the incentive to collude is a bit higher. So yeah, post-pandemic pricing pressure, cost of living crisis, and so on, supply chain disruptions, Ukraine conflict, all topics which are happening right now, and you can think what that means. If I could have the next slide, and I'm talking about the case a bit more. So the cartel case we recently completed had all parties ultimately acknowledging their role and settling with us, which was good. And they paid to us £33 million in fines for their conduct. And the case was about cartel conduct regarding the supply of prepaid cards to the public sector and in particular local authorities. So what does this mean? What is a prepaid card? I mean, it's basically like a credit or debit card, but you can never go into overdraft. It's just for the money which is on that card can be used. And local authorities use these kind of cards to distribute benefits payments to vulnerable people. So the local authorities, instead of like in the olden days using cash or checks, they issued credit. They had somebody issue credit these cards, prepaid cards, to vulnerable people, and then they could top out automatically the funds. They could also see a bit what the spending was used for. So all kind of stuff which was actually quite beneficial for local authorities and for the people who get these cards, because they also have something like banking light functions which they may not be accessible before. So the cartel conduct pertained to that though. So who was involved in it? 5 companies. First, there's MasterCard. You will know MasterCard. It's, of course, a payment systems operator. They make the magic happen, so to say, that a MasterCard credit, debit card, or prepaid card works everywhere and you can pay with it. Then there were 3 program managers who were also issuers. I'm telling you in a second what that means, but basically the 3 firms were AllPay, Advanced Payment Solutions, and Prepaid Financial Services. So these 3 firms were actually the suppliers, which the front-end suppliers to the local authorities or public service providers, who basically a local authority would make a contract with. And the program manager basically offers them to the authority a whole suite of a bundle of services, that they get cards out, that they have computer programs, that they can upload funds to the card, also that the people who use the card can check their balance and these kind of things. That's all what a program manager does. And finally, the 5th company was Solian. They're a bit specific because they were actually a service provider to MasterCard, because Solian's mandate was to promote the use of prepaid cards in the public sector, which before the cartel started or before the conduct started, that wasn't really happening. And Solian achieved this through setting up of the so-called National Prepaid Card Network, which was fully funded by MasterCard, but for a brief period. And I'm going to talk about this network in a second, because that's quite key to the case. So just zooming out a bit, we found 2 cartels, one involving all 5 parties, which I mentioned, which ran from 2012 to 2018, although not all parties participated for the entire period. And then the second cartel was only with 2 program managers from 2014 to 2016. That was APS and PFS. So now let's talk about the juicy bits for you. What did actually happen there, and how did those participants, those cartelists, target public bodies? So the investigations which we had focused on the network, which I was talking about, and this network had the in principle laudable aim to develop prepaid cards as a product for public bodies, but it also functioned as a backdrop for the cartel behavior. And so how did this evolve? In the brief initial phase, the network operated, that we found, as a kind of a steering group. So it combined a small number of local authorities which were interested in developing prepaid cards for their services, but also the program managers and MasterCard. And they sit together, discussed and thought about how they can make prepaid cards work for public bodies. And after this phase, the network then began organizing and running regional events across Great Britain, so also Scotland. And these events were set out to local authorities as a form of information piece. So this was some place where local authorities could come to a session and they could learn about prepaid cards, and they could learn how they could use them for the purposes. And at each of these events, only one program manager would attend. And here's what the local authorities were not told. There was actually that the parties secretly had actually allocated these promotional events amongst each other. So only one program manager would attend an event in a particular region. And then the parties had also agreed, if then the program manager has any leads, they call this leads, like potential business contracts from these events. So an authority would approach the program manager afterwards, for instance. They would be exclusively allocated to that network program manager. So if you, from the perspective of a local authority, you went to this event, you had no one program manager there, and the moment you contacted them and talked about them, you were allocated according to this rule. And there was then also a second network rule, which said no poaching. So the moment there was a business relationship in place, even a lead or pilot program, something like this, no other program manager would step in and start competing for your business until the contract was ultimately up for tender. And this was the first cartel we found. The second cartel picks up on the second point, which I was just saying, because as I said, the first cartel was only about until a contract came up for retender. But the second cartel touched up on that and said, and basically between APS and PFS, they said, well, if it comes up to tender, we even don't step on each other's turf. So basically, that complemented, in the sense, this kind of market sharing agreement between at least then two parties there, that basically if you were a local authority, you had less choice and you wouldn't see other businesses. So of course, this is really great. So because that we did this and were successful in it, because we put a stop to this conduct, and we issued our infringement decision in January. And this full decision is now published on our website. There are some reductions in it because they have to, but you can download it. So if you, I tried this recently. If you Google PSR cartel decision document, you will find it. It should be under the first links. And we are on our homepage, psr.org.uk. There's also a clear link to it. And in particular, if you look at Chapter 5 of this decision, you know that's all the juicy bits about how this conduct unfolded. So what is the key lesson here, maybe for an authority, for local government authority or for public bodies? So how can they avoid being roped in? So I appreciate it's actually quite difficult because, of course, the conduct is hidden. You don't know that. So the thoughts we had is maybe, well, the forum was kind of pitched as a neutral piece. Basically, it wasn't particularly it wasn't portrayed as basically particularly motivated by MasterCard or so. But if you come somewhere and you realize you only have one provider there presenting to you in something, and then you shop around, but nobody picks up on your efforts, that is something where you can scratch your head already basically a bit. And it's basically something, it's also, this is really something where you then should think, like, is there something untoward going on? So it really speaks to the importance of shopping around. That is principally the key messages. I mean, that was all I wanted to say on this one, but if you have questions later, of course, about specifics and so on, do let me know.
Thanks, Lars. Thank you. Could we have the next slide, please? Thank you. So on this slide, what we wanted to do is to set out for you where you can get further advice and information about bid rigging. So do please visit the CMA's cheating or competing page. And that page brings together lots of different pieces of information. I'm dropping something into the chat. I hope that works. That should have some links. So we have the cheating or competing campaign page, and it sets out more information on how to deter and stop bid rigging and how to how to report suspicious activity. There's a dedicated area for procurers, and in that area there is a free online learning module, and that hopefully you can go to that through the link in the chat. The campaign page also features short explainer films, so 2 or 3 minutes on what is price fixing, what is market sharing, very short but sort of quite easy to follow, and good to refresh your sort of thinking, perhaps show them within your teams. We recommend, when we've talked to public procurement teams, we've recommended that maybe they do the e-learning training module together and then discuss what issues that might have prompted or thought, or what concerns that might have sort of prompted them to think about. So do have a look at those materials. And also, one really important point that we want to stress is never confront a supplier if you are suspicious. What we want to avoid is any form of tipping off of a supplier that you're aware that there might be bid rigging happening in the market. We have had situations where that's happened, so it's really important to sort of underline how important it is you don't approach the supplier yourself, but do, because then of course they could destroy evidence. But please do get in touch with us instead. And also don't be deterred by thinking that maybe the supplier spend on your particular project isn't high enough. It might be that this is a small piece of information that fits with other information we already have, and it helps to complete a picture, enables us to open an investigation. So we do prioritize cases where there's harm to the public sector, and you could be one of many victims or one part of bit of many bits of evidence that will help us have a broader case or a more successful case. Can I have the next slide, please? Thank you. And this is just a snapshot here of different, it's a screen grab of the cheat or competing page, but it shows you what sort of thing you can look out for. On the next slide, this is really crucial, how to report to us. So if you have any suspicions or concerns, and if just something doesn't feel right, then please come and speak to us. We take all suspicions seriously, and we've got strong powers of investigation to investigate once we hear about concerns. So here we've got the cartels hotline. We've also got an online reporting form that you could use, or just an email to that address. And Lars, do you want to mention the PSR's reporting?
Sure. So, I mean, our contact details are on our homepage, which you can also contact us with if you have suspicions. But just say, if you also call the cartels hotline, I mentioned the UKCN before. So if it is something which is of our interest, the CMA would also inform us about this. That we work quite tightly together, basically, and allocate cases amongst ourselves. So cartels hotline works too.
Great, thank you. And that is all we wanted to cover here. So now over to you. Have you got any questions for us?
So Lars, Georgina, thank you very much for that. I'm going to open up now for questions in the usual format. Guys, put your hands up or questions into the chat. Guys, I'm going to start while we're waiting for people. I'm interested in your use of data. So in the public sector, you know, we have a lot of data. We have a lot of transparency in terms of our system, Public Contract Scotland, contract registers, all that kind of thing. What use do your organisations make of that wide UK data to try and identify and spot these situations?
Thank you. That's a great question. So we are aware that there is a lot of transparency in the data that's available, but the data that is of most use to us is data that shows both the winning bids and the losing bids. And from our understanding, we are unable to access that publicly. So we can access the winning bids, but without that additional data that shows the losing bids and who's been competing, and to spot different patterns. That data in itself, although it can be a source of intelligence, doesn't show us that there has been bid rigging in a market. So that's what I would say. But what we do is we actively want to collaborate and work with government departments or organisations that have information they can share with us. We do have data analytics. We do have a sort of data team, and they are able to forensically sort of look at data to see if there are any anomalies in the bidding patterns. But what they do need is both the winning and the losing bids. So okay. If as a group or department you do have that information and you would like to share that with us, we'd be interested in talking to you further. So that's that. And then in addition, we are aware there's a new procurement bill coming through, which will have, I think, even further transparency requirements. We did ask if the losing bids could be made available, but because the transparency is that it's publicly available, there's not a requirement to put in, there's not a requirement to put in the losing bids. So yes, we do work with data and we can use it, but we need to have a sort of a complete picture. Okay, thank you for that. We've got lots of questions, guys, right? I'm going to go to Douglas Niven first. Douglas, if you take yourself off mute, happy for you to ask your question.
Just a couple of questions. In the cases mentioned, were there any prosecutions of managers who were responsible for the collusion, or was it just the company? And secondly, is there a whistleblowing facility for either an organisation, because I remember Virgin whistle blew on BA for fare fixing, and what is the primary competition law that all your actions are based on within the UK?
Lars, do you want to take the just first bit about your case, and then I can deal with the other ones?
So the first thing was about, sorry, it was a lot of questions. What was the first question exactly? I noted out the other ones. Can you repeat the first question?
The first question was private prosecutions of top managers.
Got it. Okay, got it.
Responsible.
Yeah. So what we focus on in this case is the undertakings. So the framework roughly is, in very broad sketches, under CA 98 investigations, such as the ones we had, you investigate the undertakings, you don't investigate the managers. There's then a back-end story about question whether director disqualifications can follow. Georgina can talk about this maybe a bit more, but there is something basically that if you're director and you have your fingers involved in cartel conduct, that can mean that you can get disqualified by the courts for that, and then you need to make an application on that. And then there's the separate question of criminal cartel behavior. That is a crime, separate proceedings, basically. These are the three buckets broadly which we do. So the one which I'm talking about is the typical one we only investigated so far about undertakings, and the decision pertains only to undertakings.
Great. Shall I pick up some of these other points? So
Yeah.
You asked whether we have a whistleblower policy, and you also, I think, asked about leniency. You gave the Virgin BA example. So if I start with leniency first, you're absolutely right. We do have a sort of, this is a part of a sort of carrot stick, but carrot approach. We offer leniency. We have a leniency policy, and we offer leniency, which can be 100% reduction in fines to the first company that comes into the CMA or to one of the regulators with information about a cartel before we've started investigating that cartel. So that's a very strong carrot. So that that leniency policy protects the person or the company that comes in first, gives them a discount on fines, but also protects the directors against further disqualification. And that's immunity, provided you are the first in and it's before an investigation, provided you satisfy that threshold. There's also protection from criminal investigation. The leniency policy also then offers a sliding scale to the second, third companies to come in. So there is an incentive to come in and give us additional evidence. And that's all set out in our leniency guidance, which is available through gov.uk. But I'm sure if you search CMA leniency, that would set that out. We also do have a whistleblowers policy, and that is also set out on our website. But in particular, that does protect the identity of whistleblowers, and there is a sort of a group of qualified people that would deal with a whistleblower to ensure that that person could deal confidentially with the CMA. So that, yes, we do have that, and we do try to encourage people to come in. And I think there was another question about, no, I think that might have been it. Or was there a question about penalties? But, oh yes, sorry, director disqualification.
Competition law, yeah.
Competition. So what we've been talking about is under Competition Act 1998, and that's where we're talking about this civil cartel regime, enforcement against companies. In addition, we also have the power to disqualify directors. So either through getting an order of the court or by getting undertakings from that director to be excluded from being a director for a certain period of time. And this is a really important part of our enforcement powers, because what we think is that unless individual directors are accountable, or they've less incentive to comply. So the more they're accountable, obviously, the greater incentive there is for them to take responsibility and to ensure that they lead from the top and sort of take competition law compliance seriously. So over the last few years, we've really increased our use of this director disqualification power. And I think my last check, we've disqualified, I think, 25 directors from acting as a director. And that can be, and we had a recent construction case where I think a couple of directors were disqualified for more than 10 years. So it's quite a strong power to use. And we think it is a real disincentive and a way to get directors to take notice of competition law and what their competition law requirements are or obligations are. So that's that. And I think that hopefully covers the question.
Guys, that was really good. We've got lots of questions, and just as a point, we probably won't get through them all. So what we will do, like the other sessions, we'll take them, we'll come to you afterwards, and we'll put them up on our site afterwards. I'm going to pick a couple, if everyone's okay overrunning a little bit. I like Craig's question, and I actually want to add to it as well. So Craig Smith has said, you might want to write this down, guys, right? How are fines calculated? Are they effective, or is there a risk they're seen as a cost of doing business? Are there penalties for the individuals involved in the cartels? And my addition to Craig's question is, what happens to the funds received in fines? And I'm thinking more like the Proceeds of Crime Act, where organisations can bid for the greater good of society and things like that. So there's a few elements in there all around fines. I'll hand over to the guys.
Okay, I'm happy to take this one, Lars, if you're, yeah. Okay, how are fines calculated? So we have a sort of, I think it's now a 5-step procedure, but basically we can impose fines of up to 10% of worldwide turnover of the company involved. So that's big, it's really big, which is why you've seen these fines in the millions that we've been talking about. And so we have several steps we go through, but we look at what's the relevant turnover in the market that's affected, and then we increase or decrease according to whether there are aggravating factors, such as, aggravating factors. They should have known that this was, it could be a repeat offence, or it could be reasons why this is even more serious. We also reduce for mitigating factors if there are any. Oh, and sorry, we also look at the seriousness of the offence and work out at what level we want to set the fine, due to the fact that a cartel would always be our very serious or most serious types of offences. So it would be at the higher level. And then we also do a sort of balancing and looking at proportionality and then ensure that the fine is beneath this 10% cap. So it's quite a long process that we go through, but I think it means that the fines are significant, high. So we do think they're a deterrent. And in addition, maybe not time really to cover here, but in addition, those companies may be exposed to follow-on actions for damages as well. So that's something there really isn't a limit on. So yes, companies could put the risk of a penalty into the cost of doing business, but then in addition, there's these other things that may follow on, and that. So I think they're high fines, plus there are additional risks for the business. What happens to the funds received? Unfortunately, they go to the Treasury, I think. I mean, when I say unfortunately, it doesn't come back to fund us, but they go into a central Treasury pot. And then penalties for individuals. I've just touched upon it, but really the only thing we have is the director disqualification is the main way. Or if we took a criminal cartel case, that would be against individuals. But there are certain sort of thresholds to meet to do that. So the main way, I think, is through director disqualification.
Georgina, if I may add 1 point or 2 points, just to say, there's the penalty guidance which the CMA published, which is actually really helpful if you really wanted to get geeky and read about it. And other regulators like the PSR, we follow that guidance as well. And cost of doing business, this is being considered when penalties are being applied. I mean, Georgina said there's some weighing and upping. At some point, you have all these seemingly mathematical calculation, but there's a proportionality assessment. And part of that is really to look at the things in and around and see like, okay, how much money do these guys actually make? And do we not significantly increase a fine here for deterrence reasons? So there's really a lot of thinking about employers about like saying that this isn't a cost of doing business. It becomes completely hard for them, and not just like, okay, a bit more, but really also thinking about detection rates and so on. How often do we actually come to a fining decision with this, basically? So deterrence is a key point there.
Okay, guys, thank you very much. I think I've got at least 5 questions in the chat here to ask you, so we'll get them to you offline. I'm already over time, so I think the fact that we've got over 100 people sitting here and we've got all these questions is clear. This is a really interesting topic, and we'll maybe talk about doing something separate offline, which has been the case for most of today. So Lars, Georgina, thank you very much. To the audience, thank you for your attendance. Hopefully you've enjoyed today. I look forward to meeting those who are joining us in person tomorrow for our first in-person live event, our small boutique event tomorrow. But thank you all for your participation today, and thanks again to Lars and Georgina for a fabulous session. Really informative. Thank you.
Great. Thank you.
Thank you very much for having us. Bye.
Thanks, everyone. Goodbye.
Thank you.